Today, a Supreme Court decision just ignited, well, a firestorm over immigration enforcement. It's shaking up communities and fueling a national debate that really goes straight to the heart of what it means to be a nation of laws. So let's get into the details. On September 8th, 2025, that's today, the Supreme Court ruled 6-3 in a case called Perdomo v. Noam. This decision basically granted the Trump administration's emergency appeal, and it lifted a lower court's temporary block.
Right. And what that means, practically speaking, is that federal agents can immediately restart these controversial roving patrols and other, let's say, aggressive immigration enforcement tactics across Southern California.
And roving patrols.
Yeah.
Just so we're clear, that's not like a fixed checkpoint.
No, exactly. It's where agents are actively moving around, looking for individuals they suspect might be undocumented, often in public areas. And the suspicion might be based on, well, more general observations rather than specific intel on one person.
Got it. And the Department of Homeland Security, DHS, they hailed this as a victory.
They did. They called it a win for the safety of Californians and the rule of law. And they vowed to keep removing what they term dangerous, criminal, illegal aliens.
But there was immediate pushback.
Yep.
Big time.
Oh, yeah. Justices Sotomayor, Kagan, and Jackson dissented quite strongly. And local officials like L.A. Mayor Karen Bass, California Governor Gavin Newsom, they were very critical.
What were they saying?
Words like un-American, warnings that it essentially legalizes racial profiling, and even risking, quote, racial terror in communities. Really strong language.
So clearly, very high stakes, very different views. Now, you've given us a whole stack of sources here, legal memos, court opinions, news reports, even online discussions to help cut through the noise.
Right.
Our mission in this deep dive is to unpack this really complex landscape. We'll look at the constitutional limits, the political forces, the economic arguments.
Yeah.
Basically helping you understand the key facts and these sharply differing perspectives.
It makes sense.
So let's start with something really fundamental because it seems to shape everything else. When we talk about an immigration case, legally speaking, is that a criminal matter, like theft or assault? Or is it categorized completely differently?
That distinction is absolutely crucial, and honestly, it's where a lot of confusion starts. Immigration cases are treated as civil matters. They are not criminal prosecutions.
Okay. Civil, not criminal. Why is that such a big deal?
Well, it's not just semantics. It fundamentally changes the rights involved. In a civil immigration proceeding, someone, an alien, doesn't have the full range of constitutional rights that the U.S. citizen would have in, say, a criminal trial.
Can you give an example?
Sure. The Supreme Court decided this way back in 1893 in a case called Fong Yu Ting v. U.S., and that precedent still holds a lot of weight.
1893.
Wow. The court said back then that things like the Fourth Amendment's protection against unreasonable searches and seizures, or the right to a jury trial, those don't apply in deportation proceedings because, in the court's view, it's not a trial and sentence for a crime.
So deportation isn't considered punishment for a crime in the same way?
Legally, no. It's considered an administrative process to remove someone who doesn't have the legal right to be here. That single point, civil versus criminal, really dictates so much of the legal landscape we're talking about today.
Okay, that 1893 case is casting a long shadow.
Yeah.
And that brings us right back to today's Supreme Court ruling, Perdomo v. Noam, and those roving patrols in L.A. What exactly did the court say today, and why is it sparking such intense debate?
Right. So as we said, the 6-3 decision lifted the lower court's order, allowing ICE's patrols to continue. Justice Kavanaugh wrote the main opinion.
Okay.
And he tried to clarify a really fine point. He said that apparent ethnicity alone cannot furnish reasonable suspicion. So just looking Hispanic, for instance, isn't enough on its own.
Okay, that seems clear enough.
But he then added that ethnicity can be a relevant factor when you consider it alongside other factors.
Okay, what kind of other factors are we talking about?
Well, the opinion mentioned things like, quote, an extremely high number and percentage of illegal immigrants in the Los Angeles area. Also, their tendency to gather in certain places looking for work, and the fact they often work in jobs that don't require official paperwork.
So location, type of work, general demographics, combined with ethnicity.
That seems to be the idea. Kavanaugh also emphasized something else. He said the interest someone illegally in the country has in avoiding being stopped is, quote, ultimately an interest in evading the law. That is not an especially weighty legal interest.
That's a pretty strong statement.
It is. And he also stressed that judges, in his view, aren't there to make policy calls about immigration enforcement. He essentially said that's the job of the other branches, and the government has a duty to enforce the laws Congress passes.
So Kavanaugh's trying to draw a line. Ethnicity isn't enough alone, but it can be part of a bigger picture for law enforcement. But the dissenters, like Justice Sotomayor, used words like racial terror. How do they see it so differently?
That's really the heart of the conflict. Justices Sotomayor, Kagan, and Jackson argued very forcefully that these tactics are racial profiling, plain and simple, and violate the Fourth Amendment.
What was Sotomayor's main point?
Her dissent was quite powerful. She wrote, "Countless people in the Los Angeles area have been grabbed, thrown to the ground, and handcuffed simply because of their looks, their accents, and the fact they make a living by doing manual labor."
So she's saying the practical effect, regardless of the legal test, is targeting based on appearance.
Exactly. The dissenters argue that once you allow ethnicity as any factor, even just one among others, you inevitably open the door to officers relying on stereotypes and appearance. Critics, like Mayor Bass and Governor Newsom, echoed this, calling it a parade of racial terror and un-American because it targets Latinos or anyone who doesn't fit some narrow idea of what an American looks like.
So the majority thinks requiring multiple factors is enough protection.
Right. They believe it provides a legal safeguard and allows effective enforcement in areas with high numbers of undocumented individuals.
While the dissent sees it as basically giving a green light to discrimination on the ground.
Precisely. A deep disagreement about where the line is and whether that line can even be realistically enforced.
It really highlights the tension around reasonable suspicion.
Mm-hmm.
And you mentioned earlier that this isn't just about the Fourth Amendment, right? These differing rights for non-citizens pop up elsewhere in the Constitution.
They do. It extends to other areas. Let's take the Fifth Amendment, the right to due process.
Okay.
Now, anyone detained by ICE does have certain rights, the right to remain silent, the right to a fair hearing. But for undocumented immigrants, the amount of due process they get is often defined primarily by what Congress decides through immigration laws. It's not necessarily the full scope a citizen would expect.
Can you give an example of that?
Yeah, a key case from 2020, Department of Homeland Security v. Thurisigium. The Supreme Court upheld what's called expedited removal for asylum seekers right at the border.
Expedited removal, meaning a faster deportation process.
Essentially, yes, with less review. The court confirmed that federal courts generally cannot second-guess DHS's initial decision that an asylum seeker lacks a credible fear of persecution. Justice Alito, writing for the majority, put it bluntly. The decisions of executive or administrative officers acting within powers expressly conferred by Congress are due process of law.
Wow. So Congress gives the power, the executive acts, and that is due process in this context with limited court oversight.
That's the essence of it in that specific situation. It shows how due process can be scaled back by statute for non-citizens in immigration matters.
What about other rights, like free speech under the First Amendment?
Similar distinctions apply. ICE can't target someone just for peaceful protesting. That's generally protected for everyone here. But beyond that, the right's narrow.
How so?
Well, someone trying to enter the U.S. has no First Amendment right to be let in based on their beliefs or speech. And even immigrants who are here lawfully don't have all the same First Amendment rights as citizens. Campaign finance, for instance, most non-citizens can't donate to political campaigns. And Congress can even pass laws making lawful permanent residents deportable for certain activities, like speech that causes serious adverse foreign policy consequences, actions that would clearly be protected speech for a U.S. citizen.
So it's more like a set of privileges granted by Congress, rather than inherent rights in some cases.
In certain contexts, that's how the law treats it, yes.
Yeah.
And then you have the 14th Amendment, the Equal Protection Clause.
Right. Equal protection of the laws.
This is where critics bring up that point again about race. They ask, how can the law allow race as a factor in immigration stops, but reject it in things like college admissions? They see it as inconsistent, applying protections selectively.
That's a powerful critique.
It is. And on the flip side, you have some conservatives, like the legal scholar John Eastman, who argue that the whole idea of birthright citizenship, granting citizenship to anyone born here, is itself a, quote, misinterpretation of the 14th Amendment.
They want to end birthright citizenship.
They argue the amendment wasn't meant to apply to children of parents here illegally. They contend that being here illegally means you don't have a strong legal standing to claim such rights or protections under the law. So even the foundation of who gets 14th Amendment protection is fiercely debated.
This is incredibly complex. It really brings us to the bigger picture. Who actually holds the reins on immigration policy? Is it Congress, the president, the courts? Where does the ultimate authority lie?
That's a fundamental question. Constitutionally, the primary power, what's called the plenary power over immigration, is supposed to rest with Congress.
Plenary power, meaning pretty much absolute authority.
Very broad, almost exclusive power in this area, more so than in most other policy domains. However, there's a wrinkle. Some legal scholars, like John Eastman again, argue that a Supreme Court decision years ago made a subtle but crucial error.
What was the error?
It attributed this power just to the federal government generally, instead of specifically to Congress. Eastman argues this opened the door for the executive branch, the president, to take actions that went beyond just enforcing laws Congress passed.
Ah, so blurring the lines between making the law and executing it.
Kind of. And this is where you see huge controversies over programs like DACA, Deferred Action for Childhood Arrivals, and DAPA, which was a similar program for parents.
Right, those were done by executive action, not Congress.
Exactly. Critics blasted these programs. They argued they weren't just exercises of prosecutorial discretion deciding who not to deport, but were actually a categorical suspension of the law, essentially creating new categories of legal status without Congress, which critics say usurped Congress's sole power to do that.
And DAPA was stopped by the courts, wasn't it?
It was. It got blocked nationwide, partly because the administration didn't follow the proper procedures for making new rules, the Administrative Procedures Act, needing public notice and comment. It highlighted the concerns about bypassing Congress and established legal processes.
But the president does have some specific immigration powers granted by Congress, right?
Oh, absolutely. There's a law, 8 U.S.C. Section 1182, that gives the president very broad authority to suspend the entry of any group of aliens if their entry is deemed detrimental to the interests of the United States.
That sounds like a lot of power.
It is, and the Supreme Court upheld President Trump's use of this power in the Trump v. Hawaii case in 2018, the one often called the travel ban case.
Okay.
And there's even older authority, like the Alien Enemies Act of 1798, which lets the president apprehend and remove aliens from enemy nations during a declared war or invasion. So, while Congress holds the main legislative power, the president has significant, sometimes controversial authority too, especially regarding entry and national security.
It really paints a picture of ongoing tension between the branches.
Yeah.
Okay, we've covered a lot of the legal and constitutional ground. Let's shift gears a bit. Beyond the law, what about the practical side? What are the arguments about the economic impact and what enforcement strategies are being proposed or used?
Right. The economics are a huge part of the debate, especially from a conservative perspective presented in the sources. One major argument is that illegal immigration imposes significant economic costs on taxpayers.
What kind of costs?
We're talking about things like education, healthcare, law enforcement, social services at the federal, state, and local levels. One estimate from back in 2011 put the nationwide cost around $113 billion, with only about $29 billion offset by federal taxes paid by those undocumented individuals.
So a net cost, according to that study.
Yes. And a more recent analysis, this one from the Heritage Foundation, tried to project the future cost. It estimated that giving amnesty or legal status to the roughly 11 to 12 million undocumented immigrants could result in a lifetime net cost, meaning costs minus tax contributions of about $6.3 trillion to taxpayers.
$6.3 trillion. That's an enormous number. What's the reasoning behind that figure?
The main argument in that analysis is based on demographics, that a large portion of the undocumented population has lower levels of education and skills, meaning they would likely earn lower wages, pay less in taxes, and potentially utilize more government benefits and social services over their lifetimes compared to their tax contributions.
So it's a long-term projection based on skills and potential earnings versus potential use of services.
Exactly. And there's another economic concern sometimes raised, which actually came from civil rights leader Barbara Jordan back in the 90s, the idea that importing large numbers of low-skilled workers could increase job competition and potentially depress wages, particularly for, quote, the working poor and black workers.
Okay, so concerns about taxpayer costs and labor market impacts. Yeah. Given those concerns, what are the enforcement strategies proponents suggest?
One key strategy often discussed is aiming for self-deportation. The idea isn't necessarily rounding everyone up, but making it much harder to live and work here illegally.
How would that work?
Primarily through strict enforcement against employers who knowingly hire undocumented workers. Think penalties, prosecutions, maybe even losing business licenses. Arizona's mandatory e-verify system is often cited as an example, making it harder for employers to hire someone without authorization.
So cut off the job opportunities.
That's the theory. If people can't earn money, proponents argue, many will choose to leave voluntarily. Another tactic is limiting access to state-level benefits, like driver's licenses, which Alabama did, again making it less feasible to stay.
Is there evidence this approach works?
Well, proponents point to the Trump administration's first 100 days. They cite data showing that with ramped-up enforcement and rhetoric, illegal border crossings dropped dramatically, encounters down 95%, and gotaways, people who evade capture, reportedly fell 99%. They see this as proof that strong enforcement deters illegal immigration.
And what about sanctuary cities? That's always a flashpoint.
Definitely. From this perspective, sanctuary policies where local governments limit cooperation with federal ICE agents are seen as actively undermining federal law. Critics argue they create safe havens, potentially for criminals, and violate federal statutes that require communication between local and federal law enforcement about immigration status. Some argue it gives undocumented individuals more protection from the law than citizens in certain ways.
So the focus is largely on stricter enforcement of existing laws and removing incentives or protections.
That's a major thrust. But it's not the only conservative approach discussed in the sources. For instance, some California Republican lawmakers have actually pushed for modernizing the system.
Modernizing how?
While still supporting enforcement against criminals, they've suggested creating a pathway to legal status for non-criminal undocumented immigrants who've been here a long time, built ties to the community. They also propose expanding legal guest worker programs like the H-2A and H-2B visas to meet labor needs legally.
So a mix of enforcement and finding legal avenues.
Kind of a law and order with compassion approach, you might say, trying to balance border control with economic needs and the reality of people already here.
And is there anything happening at the national legislative level reflecting these enforcement ideas?
Yes, Senate Republicans, with Senator Chuck Grassley leading, have proposed what they're calling the One Big Beautiful Bill. It's a package aimed at several things.
Like what?
It includes historic investments in border security, more funding for law enforcement, measures to allow for quicker expedited removal of immigrants convicted of crimes. It also proposes setting up a Biden reimbursement fund, that's an acronym for border infrastructure, detention, enforcement, and national security, to help states pay for costs they attribute to federal immigration policies they disagree with.
Interesting name for the fund. Anything else in that bill?
Yeah, significantly, it also tries to push back on the judiciary's role. It aims to restore the constitutional role of the federal judiciary, as they put it, and specifically challenge the use of universal injunctions.
Those are the court orders that can block a federal policy nationwide.
Right, exactly, even if the lawsuit was just in one state or district. The bill reflects a view that courts have overstepped in immigration matters, and it seeks to limit that power alongside boosting enforcement. It really ties together the themes of enforcement, federalism, and separation of powers from their perspective.
We have certainly navigated a really complex legal, political, and economic landscape today. This deep dive really shows a nation grappling with these fundamental questions: sovereignty, rights, economics, community.
It absolutely does. And given everything we've discussed, the shifting court interpretations like today's ruling, the deep ideological splits, the very real impacts on people's lives and communities, it really leaves a crucial question for you, the listener, to think about. How do we as a nation actually reconcile the government's clear constitutional authority to control its borders with the very human stories, the economic realities, and the constitutional rights arguments surrounding immigration, especially when the way we interpret all of those things is so fiercely contested as we've seen today? It's definitely something that requires thought far beyond the headlines.